They're going to say you wanted it. They're going to say you're lying for money. They're going to dig through your personal life, your social media, your dating history, looking for anything to destroy your credibility. If you're thinking about filing a sexual harassment case, you need to understand the defense is not just going to fight your case. They're going to fight you. I'm Brian Hannemann, 33 years representing harassment victims in California. I've won million-dollar verdicts against Fortune 500 companies because I know exactly what their defense teams are going to do, often before they know it themselves. Stay with me because what I'm about to show you could be the difference between justice and devastation. Here's what you need to truly understand about sexual harassment defense work. It's not about proving their client is innocent. Oh no. It's about proving you're not a credible victim. The defense knows that juries want to believe harassment victims. We've come a long way since the 1970s. Studies show this consistently. So the jury's job is to decide the case, but the defense job is to make the jury not want to believe you specifically. I've sat across from some of the best defense teams in California. They're smart, they're well-funded, and they have a playbook they use in every single case. The playbook has 6 core strategies, and I'm going to walk you through each one so that you can prepare for what's coming. And they can't stop it because you know what's coming. Here's the thing. When you know what they're going to do, you can neutralize it before it starts and be ready for this. Defense strategy number 1. She wanted it. They're going to claim it was consensual even when there's clear evidence of harassment, even when there's proof of power imbalance. They're going to argue you welcome the attention. Here's how they're going to do it. They'll take any friendly email you sent, any time you smiled in a photo with the harasser, any social interaction outside of work, anything. They're going to twist it into evidence of consent. I had one case where my client sent her boss a thank you email for a work recommendation. Perfectly professional, and the defense argued it proved she was, quote, pursuing a romantic relationship. How do you protect yourself? Okay, from day one, keep all communications professional. It seems obvious, but please, you need to do this. No friendly chit-chat in texts. No casual after-work drinks. I know this sounds harsh, but friendly behavior gets weaponized. The more professional distance you maintain, the harder this strategy becomes for the defense to use. She's misremembering. They'll say your memory is faulty, or you're exaggerating minor incidents. You're blowing things out of proportion. This is particularly common when there's a time gap between the harassment and the reporting. They'll bring in expert witnesses on memory and trauma, arguing that traumatic experiences create false memories, or that victims unconsciously exaggerate over time, or they'll blame your lawyers for putting words in your mouth and creating a story. They'll focus on any small inconsistency in your story, even normal human memory variations, anything. If you didn't report it at the time of HR and then you bring it up later, they're going to point that out. How to protect yourself. Okay, document everything immediately. Date, time, location, exact words if possible. Email yourself a summary the same day. Don't rely on your memory months later. You need to create the record when it's fresh. and understand that minor inconsistencies are normal and expected. Perfect memory is, contrarily, actually suspicious to juries. Now we're at defense strategy number 3, the character assassination. Of course, they pick on you. Look who's making these claims. They're going to try to destroy your reputation every single time. They'll dig through your social media going back years. They'll look for provocative photos, party pictures, dating app profiles, anything that makes you seem sexually promiscuous or unstable. In California, the law, Evidence Code Section 1106, is supposed to protect victims from this. It's supposed to limit evidence about a victim's sexual history. But defense attorneys are creative. They constantly dig into it. They'll find ways to bring up your personal life under different legal theories. Here's how you protect yourself. Clean up your social media now. Make everything private. Remove anything that could be taken out of context. This isn't about judgment. This is about reality. A jury that sees you as a party girl, well, they're going to be less likely to believe you're a victim. It's unfair, but it's true. Defense strategy number 4, the financial motive attack. We get this in every case as well. You can imagine. She just wants the money. They're going to claim you're making false accusations for financial gain. This attack is especially potent in high damages cases or when the harasser is wealthy. They'll point to your financial situation, such as student loans, credit card debt, recent job loss, got a divorce and now you're struggling, maybe single mother, anything that suggests you need money. They're going to argue that filing the lawsuit was a business decision, not a search for justice. How do you protect yourself? Be prepared to explain your real motivations. Most of my clients file lawsuits to prevent it from happening to others, to get acknowledgement that what happened was wrong, or because they lost their job and they need money because they're out of work and it wasn't their fault. Those are legitimate reasons that juries understand. The retaliation excuse. Okay, she's making this up because she got a write-up, she got counseled, she got disciplined, she got demoted, she got fired. Okay, if you were fired, demoted, disciplined, whatever, after you rejected harassment, they're going to flip that script and turn it on you. They're going to claim the employment action came first and you invented the harassment as retaliation for legitimate discipline. They'll dig through your performance reviews, attendance records, any workplace complaints against you, no matter how minimal. They'll try to show you were a problem employee who fabricated harassment claims to avoid responsibility. Well, here's how you protect yourself. Keep copies of all your positive performance reviews, your commendations, your awards, good texts from coworkers and bosses. Document any sudden changes in how you're treated after rejecting advances. It happens almost every single time. The timeline matters. If your performance reviews were great until you said no, well, that supports your case. Everyone talked that way. Oh, that's just him. They're going to argue that crude language and sexual jokes were part of the normal workplace culture, and you knew that when you took the job. This is especially common in male-dominated industries. They're going to call coworkers in and testify that, everyone joked around and that you participated willingly in inappropriate conversations. They're going to try to show you were not actually offended at the time. Here's how you protect yourself. Make it clear from the absolute very beginning that sexual comments make you feel uncomfortable. Say, I don't like it. Please stop. No. Send emails saying, please keep our conversations professional. Again, contemporaneous corroborating evidence of how you're feeling is really important to a jury later. Report inappropriate behavior to HR in writing. Create the paper trail showing you objected to the hostile environment. Now, the counterpunch strategy, how to defeat their playbook, right? Now that you know their strategies, here's how you beat them. You start documenting before you file anything. Every conversation, every inappropriate comment, every retaliatory action. Denied a transfer, denied a promotion, transferred to a less than desirable lateral position, that all counts. Use contemporaneous notes. That means notes made at the time, not built later. Report through proper channels first. File with HR. File with the California Department of Fair Employment and Housing. This shows you tried to resolve it internally, and it protects you from retaliation claims later. Get therapy if you think it's going to work for you. I know it sounds like legal advice you wouldn't expect, but trauma counseling serves two purposes. It helps you heal, and it creates a medical record showing psychological harm. Therapist notes are powerful evidence. Keep working if you can. I know it's hard, but quitting gives them ammunition for, well, she just wanted to leave anyway. If you're forced to quit due to harassment, document exactly why in writing and say so. Finally, find witnesses who support your character, not witnesses to the harassment. Those are rare, but find them, of course, if you have them. But find witnesses who can testify that you're honest, professional, and not someone who would make false accusations for money. Here's what victims really face. And listen, please understand, I'm being completely honest with you. Filing a harassment lawsuit is not easy. Defense teams are well-funded and ruthless. They will make you relive the worst experiences of your professional life in excruciating detail. But here's what I've learned in 33 years. When victims are prepared for these attacks, when they understand the game being played, they win. My clients have recovered over $10 million in harassment cases because we anticipated every defense strategy and neutralized them in advance. The Vandervoort case against Fontana Unified School District, hard fought, multiple years. $1.5 million against the school district plus a $5 million punitive damage hit against the individual harasser. They tried every strategy I just described. We were ready for each one and beat them at every single defense they tried to hoist up. The key is preparation, not just legal preparation, okay? It's psychological preparation. You need to understand that the defense will attack you personally, your credibility, your character, your motivations. When you're prepared for that, you can handle it. Here's the decision point. If you're dealing with workplace harassment right now, you have a decision to make. You can stay silent and hope it stops, and then you'll be a victim the rest of your life because you never fought back. But predators, they're not going to stop on their own. And you know that. So you can fight back knowing it won't be easy, but it can be successful. If you choose to fight, please don't do it alone. Find an attorney who specializes in harassment cases and knows these defense strategies inside and out. Your case is not just about you. It's about every future victim who won't be harassed because you had the courage to act. I'm Brian Hannemann. If you need help making that decision, call me.